Hi, my name is Dave, based criminal defense attorney, and today I'd like to discuss with you basically what it means to be charged with transportation of narcotics in California. There's two types of ways you can be prosecuted if you're alleged of transporting narcotics in California. The first is you can be charged federally, and federally we usually see in a place like San Diego if it's cross-border smuggling, drug smuggling. You're alleged to have come across the border at San Ysidro or Otay Mesa with a certain amount of drugs. State court for transportation of a controlled substance or marijuana. These are non-reducible felonies. These are really serious cases, and it's essentially you hire the right attorney, the attorney with the experience in handling these types of cases. There was a time when simple transportation of a controlled substance would be even if you just had a usable amount. Now, I think it was last year, the law changed, I think in January of 2014, which makes it required that in order to be charged with transportation of a controlled substance, it needs to be for purposes of sale. So you're not going to get charged with transporting a controlled substance as a non-reducible felony and be subjected to years in state prison if you're just transporting a usable amount, not necessarily something possessed for sale. So that's a recent change in the law. But obviously they need to prove that what you possessed was in fact possessed by you, and that could be proven, was in fact a controlled substance or a drug, marijuana, and was in fact possessed and transported from point A to point B. So the general defense obviously is knowledge of the drugs. A lot of times people come across the border and they might not know what's in their vehicle, but if they keep their mouth closed, the government needs to prove that they in fact had knowledge or should have had knowledge of what was in their vehicle. Far too often, people get in a situation where they get pulled over and a canine unit or a drug sniffing dog could detect or get a hit on something, and then they start talking, and yeah, I knew there were drugs in the car. Well, that usually doesn't help you. There's always a necessity or duress defense, but that's a stretch. Those are successful under the right circumstances, but the goal is, like any case, particularly in transportation of narcotics cases, is that you keep your mouth closed, don't admit you knew what the drugs were, you don't admit anything, don't close doors to your defense. Give your attorney, the right attorney that you hire, as many avenues of defense as possible.